We are once again talking about a shocking case, a teacher accused of crossing the line with a young student, this one not even a teenager, but that teacher is now going to face the criminal justice system. This time we're talking about a teacher in Louisville, Kentucky, a fifth grade math teacher. Here she is making her first court appearance, trading in a classroom for a jail cell, weeping as she faces charges of an unthinkable crime with an alleged victim under the age of 12.
You are charged with procuring or promoting use of a minor by electronic means. It's a C felony. I'm going to enter a plea of not guilty to that charge. Right now the bond is $100,000 full cash.
That video is of Sydne Graf, a fifth grade math teacher in court per WLKY-TV in Louisville, Kentucky. We have what she specifically reportedly said to a student and why where she was arrested may have been just in the nick of time before things got worse, and why the location of her arrest could be crucial to the case that prosecutors will make against her. We're on The Case, presented by Law&Crime. I'm Stewart. Hey guys, real quick, if you're looking for a deal on a great gift or something just around the house, the Chef IQ Sense Smart Meat Thermometer, have one right here, you can see it. This is the secret to stress-free, flawless cooking. Maybe you're a seasoned chef or you're just starting out. The Smart Thermometer, it guarantees perfect results every time, so no more guessing, no more overcooking. Just insert the probe, select your food, cooking method, and preferred doneness. Then you can relax. Your app will alert you when it's time to flip, remove, or rest. It is perfect food every time. Maybe it's a holiday turkey, prime rib, wings, whatever it may be. It works for everything. Oven, grill, smoker, fryer. You can't mess this up. It is the gift that makes cooking stress-free and fun. And with my code OTC, you can save 30% off site-wide at chefiq.com. It would be easy to start this story and say, once again, we're talking about another teacher that is accused of crossing the line with a student. But then I think it would make it seem like that this is just all too common and it's becoming normalized, and it should never be this way. But we have seen a lot of these cases. And if what is alleged in this case out of Kentucky is true, it is truly a good thing that this teacher was taken into custody and law enforcement got involved before she went even further and did even more damage to a young boy who she was the teacher of. This is an elementary school student we're talking about as a victim in this case. Of course, this teacher innocent until proven guilty, but let me lay out the case that police and prosecutors in Louisville, Kentucky are making against her. First, let's start with the video, once again, of Sydne Graf, fifth grade teacher. She's in tears in her jail jumpsuit as she makes her first court appearance in Louisville after her arrest, which came roughly 10 days before Christmas. Now, seeing this teacher like this, it is probably a shock to the people that know her, the kids that were in her classroom, the parents that trusted her with their children. Because on the surface, it does appear that Mrs. Graf was the kind of teacher that people could trust, that as a parent you might want as the teacher in the classroom for your child, the kind of teacher that would do anything for her students. I mean, look at this Facebook post. This is from May, and it's her with a link asking people to donate money so she could make sure that her students have the best learning environment possible. She posted this on May 15th saying, quote, "I teach fifth grade math at the best school in the entire world. I am trying to raise enough money to get rid of those old, outdated student desks/chairs and replace them with flexible seating options. Please consider taking a moment to donate whatever you can to help us reach our goal and add to our dream classroom environment." And then when you click that link, you can see that she says, quote, "My students are some of the brightest, most kind-hearted children I have ever had the privilege of teaching." Now, personally, in court, it was said that this woman who will do anything for her students, she's also married and she has 2 kids of her own, which is always just so incredibly shocking that she would allegedly go as far as she did and say what she allegedly said. She actually wasn't always a fifth grade teacher. She was a fourth grade teacher at the time that she had posted that link to donate, and she said she just loved these kids so much that she was actually going to loop with them and join them in the 5th grade the next year so she could continue to teach these kids. She taught at a school in Jefferson County, Kentucky, a public school. Here's the Facebook post mentioning her as a 4th grade teacher in 2024, and that she is, quote, excited and ready for our feisty 4th graders. Now, perhaps the image of a teacher that loves her job, for as difficult as that job can be, and that she's willing to go above and beyond for her students, maybe that was just a cover for who this woman really is. It's hard not to think that with what she's accused of. So let's dive into the criminal part of this case now that you get an idea of who Sydne Graf, 36-year-old 5th grade math teacher, was to the public on the outside. Because in the eyes of the police in Louisville, she's a sexual predator. We'll see what the court system figures out there. Of course, that's all alleged at this point. The 36-year-old was arrested on December 15th, so we're talking 10 days before Christmas. Police say it was a Monday, and school was a non-traditional instruction day, which apparently means the kids were not in the classroom and they were learning remote. Now, People has the arrest citation that says that the Jefferson County Public Schools police contacted Louisville police about alleged, quote, exploitation of a juvenile victim. So they got word that this was going on apparently, and it is alleged that Mrs. Graf was having sexually graphic conversations with one of her 5th grade students. Again, we're talking about somebody under the age of 12 years old. Police say that Graf talked to the boy about oral sex. Specifically, she allegedly said, and I quote, "I really need to taste that D word for genitalia, FR, which means for real, for real." Then in the conversation, Mrs. Graf, on this remote learning day, allegedly made plans to go and see this student in person, but that is when police stepped in, potentially stopping this woman just in time before things became physical. She was arrested while she was actually allegedly going to pick the boy up at his home because she was arrested in the area of his house, police say. They also go on to say in the citation that they can see the messages were coming from Graf. They know it was her because there are pictures that she sent on the account that prove it was her. They also say when she was arrested, she allegedly admitted that she sent the message. And this was after she read her Miranda rights. So you can see this case starting to take shape for prosecutors, because not only do you have this incredibly disturbing message that maybe was picked up by law enforcement because it was a remote learning day. Was this done on some sort of school Wi-Fi, school computer? It's unclear. Then you have her apparently, and in the eyes of the law, the eyes of law enforcement, acting on this by going allegedly to the boy's house. She did give some body language in court that might push back on that though, which will be interesting to see. We'll talk about that in just a moment. And then you have her after she's read her Miranda rights the next day when she stood in front of a judge, and you can see the emotion hitting her. Tears in her eyes, she's weeping, she's sobbing as she made her first court appearance in Louisville. This video per WKLY TV. Listen to this.
Pontoon, maybe?
Good morning. Hang on just a second, I don't have your file yet.
She may need rights. I think she was in the same cell.
Okay. Before we address your case, I want to make sure you understand your constitutional rights. First of all, the right to remain silent. You don't have to talk to anybody today. This gentleman's with the PD's office, Public Defender's office. He's here to help you if you have any questions. We're going to enter a plea, most likely of not guilty. Figure out your next court date, figure out your attorney situation. You do have felony charges, so you have a right to a preliminary hearing before a judge to determine if that crime was committed and committed by you. If you remain in custody, that hearing has to be held within 10 days of today, your arraignment. If you get out of custody, it has to be held within 20 days of your arraignment. On down the road, you have the right to a trial and a right to appeal. But for today, we're going to enter that not guilty plea, figure out if you want to hire your own attorney, if you qualify for a public defender, figure out your bond, and figure out your next court date. Okay? Okay, hang on one second. You are charged with procuring or promoting use of a minor by electronic means. It's a C felony. I'm going to enter a plea of not guilty to that charge. Right now the bond is $100,000 full cash to HIP if posted with no social media. And you say you want to hire your own attorney? Okay.
Judge, I apologize.
Okay.
I believe this was Grant, correct, Judge?
Yes.
Okay. I'm going to enter an appearance in the case at this point in time, at least for the purposes of arraignment only. with the court's permission.
Okay.
Okay. Sydney, I'm going to enter a plea for you. Do you understand that?
Yes, sir.
Judge, we're going to admit her identity, waive formal reading of the charges, reserve the right to file any appropriate motions at a later time, and enter the plea of not guilty.
All right, we'll enter that plea of not guilty. Note you, at least for today's purposes, Mr. Miller, the bond is $100,000 full cash to HIP if posted. She is a low one.
Could we address the bond issue, Judge?
Of course.
She's been a long-time resident here, Judge, her entire life. She owns property here in town. She has 2 children here in town. She's married. She has her family, her sister, and they all are here. She's at slight risk. She is not. She has one charge back about 2006 or 8, a traffic violation. That's the only charge that I know of that she had, and I represented her back then. So that's the only charge I know of at this point in time. I realize that the charges are serious, but $100,000, Judge, is a question she could not possibly make that. I would suggest, if at all possible, 10% a lesser amount or that amount.
The defense tried to get Graf's bond lowered, but prosecutors countered with how serious the charges are. And I want you to notice, as the prosecutor is laying out the reason that they don't believe that bond should be lowered, that it should be kept at $100,000 cash, the full bit, not a partial bond payment or house that could be put up, $100,000 cash. Watch how Graf's body language changes as this case is laid out.
All right, Ms. Southern.
Your Honor, based on the nature of the allegations, the county would strongly object to a bond reduction at this juncture. We are asking for there to be a written no contact order, and that would be no contact with the juvenile victim, no contact with the place of violation, no contact with any minor children, no social media or electronic devices, and no contact with any JCPS property. Our position, as I said, is that given the facts and circumstances as set forth in the the uniform citation, that this bond is completely appropriate, and we're not disagreeing with Mr. Miller that her prior record consists of a 2008 DUI, but nonetheless, these allegations are extremely serious. There are allegations of certainly contact.
I apologize, was I not correct that the traffic violation was like in 2006 or 8? It's like 15 or 20 years old, 15 years old.
I said I agreed with you.
Oh, I apologize.
Yes.
I didn't understand.
That I said I agreed that there was a 2008 DUI, yes.
I'm sorry.
The allegations here are certainly extremely serious, extremely concerning, related to the alleged contact with the juvenile in question, and then certainly of additional concern are the allegations that there were then not just contact that was electronic in nature, but then arrangements being made to meet the juvenile, and looks like there were actual attempts of picking up that juvenile from his residence.
And you can see there she mouths no. And this was at the point where the prosecutor's talking about her allegedly going to pick the boy up from his house. Remember, she was arrested near the child's home, according to police.
Which is where the citation indicates that that's where she was apprehended. So as I said, our position is that this bond is appropriate and should not be changed in any way.
All right, Ms. Graf, I am going to leave the bond where it is, $100,000 full cash to HIP with no social media and absolutely no contact with the victim in this case. No messages through a third party, no email, snail mail, nothing like that. All right?
Judge, could I ask, could we, the ability to post real property, Judge?
No.
Cash only. Correct, Judge?
Correct. I never do real property.
I'm sorry, you never do real?
I never do a property bond. Always cash. 12/26, 9 a.m.
302.
12/26 at 9 a.m.
Yes, sir.
In which court? I'm sorry.
302.
And then
Thank you very much, Your Honor.
I'm guessing Mr. Miller will be there. since even though he said for arraignment only today?
Graf's bond remained at $100,000 cash. She posted bond and is now on house arrest under strict conditions that she can't have contact with the victim or use the internet. Her case was then waived to the grand jury, where we'll see if and when she is indicted on charges related to this case. This is according to WKLY TV in Kentucky. She is next due in court January 26th. Now, after her arrest, the principal of her school released this statement, quote, "Dear Smyrna Elementary School families, the safety of our students is our top priority, and we always want to keep you informed to the best of our ability about what's going on at our school. We have been made aware that the Crimes Against Children's Unit, JCPSPD, and LMPD are investigating an allegation involving one of our staff members. Following JCPS protocols, the staff member will be reassigned and will not have contact with students during the investigation. Because this is an active investigation, I cannot disclose anything more at this time. We know situations like this can cause anxiety for students and families. Our mental health team is always available. If you feel your student would benefit from talking with our mental health practitioner or counselor, please let us know. Thank you for your continued support of Smyrna Elementary School." Joining us now to talk more about this case is former sex crimes prosecutor Dan Shore. Thank you as always for taking the time to be with us to talk about these, because it just does seem like it happens a good amount. In this one, though, it seems like law enforcement stepped in, before it got to something, potentially scarier. What stood out to you just so far with what we know?
Well, one thing is the age of the alleged victim, that he was in the 5th grade. This is a teacher in her 30s, so huge age difference, power differential. The fact that one person's a teacher, an authority figure who's in a position of trust. Here's someone who is at an elementary school age level, and the allegations are that she was communicating with him about oral sex. And well, it hasn't gone to a grand jury yet, but once it does, if there's an indictment, we'll probably learn more specifics about what the charges are, but certainly those facts are extremely concerning.
The timeline that we were given is it's December 15th. It's on some sort of remote learning day for the school district, and it was the school district police that then contact the Louisville Metro Police about, this happening. Here's the message that she sent. They didn't say specifically, from what I saw, like the platform it was on, but if the school district knew about it and then contact police, is it possible that there was some sort of like messaging app within the district that could, is there software that can pick up on, certainly the words that she is accused of saying to this kid is something that would flag, potentially, I would think, some sort of software the district has.
Yeah, that's one possibility. Another possibility is that I have kids this age, when they have a phone, anything they put in their phone, if you have proper settings, it notifies you if there's anything related to bullying or violence or sexual content. So it's also possible that it was flagged when the student received this, even if it wasn't on a school app, that the communication happened, because I, as a parent, would be notified if someone was texting with one of my kids about something with this content. So that's another way, but it might have been found out. In any event, law enforcement was notified, and that's obviously a very good thing here.
It stood out to me too in the way that, there's this very graphic sentence that she allegedly sent this student, but the part that stood out to me at the end of it is the FR, which is for real, which is, I'm older than that generation, but that's kind of like slang term that people use these days. This kid is very young in the 5th grade, but it just seems like she's trying to level with them almost. And I guess as someone who's prosecuted these types of cases, what stands out to you with just kind of using that type of language in the way that she's talking to this kid?
Well, one thing is just the fact that obviously if the teacher did really send this, and obviously she's innocent until proven guilty, but the language is something that shows that she felt really emboldened to do this, because if you are sending suggestive, sexually explicit content to a 5th grader and you're doing it over any kind of messaging service, you have to know that it's going to be preserved in some level, and it could be evidence against you, and you're risking your career, you're risking your freedom, because you could face jail time for something like this if she's convicted. So it strikes me as a very emboldened person to put this in writing with a 5th grader, and either being aware that you could get caught but just trusting this 5th grader, or just being oblivious to the fact that if people find out about this, there are severe consequences for her life. So that's something that really stands out to me.
Well, and it stands out to me too. I mean, it's always, and this isn't the first one that we've talked about where there's this dynamic, but it's like she doesn't really have a criminal record. She seems like she is the model teacher who's going to do everything for her students. She's married. She has kids herself. How is it in some of these cases, and I know I feel like I've asked you this every time that we do one of these, but it's like it's just so shocking that someone who would do something like this, but then also at the same time, it doesn't seem like it's not like it was the creepy gym coach that everybody's like, oh, I knew that this guy was up to something or she was up to something. It just seems like this is so out of the blue.
Right. Well, I've investigated so many cases of sexual misconduct involving teachers and other people in authority, both as a prosecutor now with a lot of different colleges, universities, and K-12 schools. And one thing I see repeatedly that it often is the person who's in a position of trust and sometimes universally trusted by people who can be the person who commits an offense like this. That the person, like you said, the person who comes off creepy, it doesn't engender trust from people, doesn't allow either parents to say, oh, you're messaging with this teacher, that's fine, I know them, they're trustworthy, right? The person who seems really creepy, parents are going to be more suspicious. So often it could be the sports coach who's beloved by the community, or a religious figure, or a teacher, someone here who's in their 30s, married, female, which makes people view it as less threatening, although certainly we have many cases where a female teacher commits sexual misconduct, but certainly it's going to be less threatening to a parent just based on stereotypes than a male teacher doing it. So I think often it's those people who seem most trusting or should be most trusted, those are the ones who can get away with something like this when others can't.
I think a big part of this investigation, and just from what I've read, is that after she was read her Miranda rights, she somewhat admitted to sending this message. But without that part of it, and in some of these cases where, I mean, thankfully, police were able to stop her if she was actually going to pick this student up and act upon whatever she's accused of saying and all of that. But at the same time, like, how challenging are some of these cases in proving that she's the one who sent the messages and that there was actually intent behind it?
Well, in terms of who sent it, I assume that law enforcement will try to look at her device, whether it's a phone or a computer, or where they'll subpoena the records from whatever messaging service this was a part of, and they'll be able to tell which account it was sent from. So if she's going to say it wasn't sent from, I didn't do it, even though it was from my account, law enforcement will look into that. So I think that generally law enforcement will figure out whose account it was sent from, and then the defendant can say, well, someone else did it from my device, but that's really hard to believe often. Often in the cases where we see messages like this, someone admits to it but says that they didn't intend it to be as bad as it sounds. Now, for that, I think law enforcement is going to want to look at other messages she sent, because I think we could be pretty certain that if she sent this sexually explicit message, it didn't just come out of the blue. Someone's not just out of nowhere just texting a fifth grader about oral sex. Every case I've seen that involved this type of conduct, there is a grooming process, and it increases in terms of escalation of the explicit nature of the communication before you get to something like this. So I think you would think there's other communication between them that law enforcement is going to look at, and they could do that by subpoenaing different records. And then we'll learn more about what kind of interaction she was having, and that goes to show intent also.
When it comes to building a case, the fact that it appears that they made some sort of arrangement that she was going to go meet up with him, that's what police have said through all the media reports we've seen. And then they catch her in his neighborhood. In the process, they say, of picking up that student. I mean, how important is that to building this case against her?
That's extremely important for intent and also for the seriousness of it. The explicit messages are serious enough, but it's another level of seriousness when someone is going to, in person, connect with someone after sending sexually explicit messages, because the implication may be that they're intending to engage in some type of sexual activity with someone who is a fifth grader here. So the fact that she was in the neighborhood supposedly trying to meet this boy, that's powerful evidence. Now, she may have an explanation for where she was and why she was there, but certainly that's going to be a crucial part of showing not only intent, but also, if she is convicted, what is the sentence by a judge? A lot of it depends on the intent, how egregious it was, and how far someone was looking to carry out this misconduct, and that's a big part of that.
And it's so, I mean, just that one message that we know that she allegedly sent is just so shocking, especially to a fifth grader. And we don't know, and we'll see if and when she's indicted by a grand jury, like some of the other information that comes out, other text messages, but like you talk about grooming, like how does the process go from, even if it's just, and we don't know what type of interaction they had, and if there is evidence of any sort of physical interaction in the past, what the relationship was, maybe she was a family friend, we don't know. But like, how does it begin in some of these cases to get to the point where someone is sending this type of message to such a young person?
In many cases I've dealt with where this grooming, it usually comes across first as just innocuous, friendly behavior, getting someone's trust, getting the family's trust. So it could be just talking to someone, talking to this student, becoming somewhat of a mentor, someone who's trusted, maybe even connecting with the family. And then what we see over time is boundary blurring behavior. A lot of times we see cases where there's hugs, maybe kisses on the cheek, things that someone might explain as not explicitly sexual. And then people feel emboldened to push those boundaries. Sometimes we call it boundary probing, where you're seeing, well, what is the boundary that I could get away with? And we see people pushing that until it leads to more explicit either contact, like real explicit sexual interactions, or maybe just messages that are explicit. But I think from the point of the child, often they don't see it as wrong because it's someone who's friendly, someone in authority who is doing this. And we're always told as kids, I know I was, trust your teachers, listen to your teachers. If your teacher tells you to do something, you better listen to your teacher, right? That's what kids are told. So for a 12-year-old who has a friendly seeming teacher who tells them things and is acting nice to them from what their perspective is, that can lead them to trust them, and then the boundary gets pushed and pushed. And we see that tragically in many cases where the ultimate conduct is even more egregious than what we're seeing here.
In this case, I know she's on house arrest now, but the judge in her initial court appearance was very strict, it seemed, as judges should be in these cases, where it was $100,000 cash. She said no partial. She couldn't put up physical property. What does that typically mean? And how much, if she were to get a bail bond, because they were pretty strong in saying, at least from her public defender or personal attorney at this hearing, that she wouldn't be able to post even a partial amount of that $100,000. How is she able to post that eventually to be able to get out on bond?
Sure. So the way the bonds usually work is there's bail bond companies that will post a bond for you, and you have to put up some kind of collateral or a partial payment to the bond company. But if you don't appear in court, then the bond company and then the defendant are on the hook for that amount of money, because the bail bond company is entitled to that payment from the defendant. So what it ultimately does is that this defendant, if she did not appear in court again, could forfeit $100,000. And often the biggest part of a bond or bail is to secure people returning to court. So it's trying to make sure that people don't just leave. And financial incentives often do make people come back to court. Doesn't always work, but that's a big part of making sure people appear for the next court appearance.
I noticed in the statement that was put out by the school she was at, that she was being reassigned. Mm-hmm. And I know that can change. Sometimes we see that teachers are put on leave pending the outcome of an investigation. Sometimes teachers are fired. In this case, reassigned. What do you think that actually means? Why is that, I guess, the approach that some districts go, as opposed to in some cases we see teachers get fired on the spot?
Sure, and I do see this all the time in my investigations. There are some, especially more private schools, are able to, I believe this is a public school teacher, and in public schools you're more under the rubric of federal Title IX regulations and policies, and what that usually means is that if there's a sexual misconduct type of offense that you're alleged to have committed, you can't be sanctioned until the school goes through their process internally of adjudicating the matter, that you can't just summarily dismiss someone the way a private school that's not getting federal funding might have more discretion. So this is a public school teacher. It's really common for a public school to say, well, we're not going to have this person interact with children anymore. We're going to go through our process that will probably lead to termination if it shows that they did what they're accused of. But for now, they're going to be reassigned. Sometimes that reassignment means they're not doing any work, that they're just being paid on paid leave or put in a room somewhere where they have to do just record-related work that's not interacting with other people. But the main point is that often under federal law, under Title IX and policies, public schools can't just fire someone without going through their process, and that's usually why they have this intermediate step.
On the civil side, in cases like this, how could, and I don't know in this case, I mean, she certainly was a teacher for a period of time. Seems like from everything we've, just from public facing, seems like she had done everything the right way, and then this happens. How could a school district be, I guess, vulnerable in a civil sense, knowing if she's found guilty of what she's accused of?
Well, a big part of that is what if the school did anything wrong. So did the school miss something in a background check? Many of these cases, they did not miss anything. That if someone doesn't have a criminal record or civil record or disciplinary history or social media that shows that they are doing this type of misconduct, then there's no way you would know about it if you're the school. The other part of it is, were there early warning signs that were flagged by an employee but the school didn't respond to them? Someone might have seen other misconduct, inappropriate interactions that weren't properly investigated. So those are the type of things that get schools in trouble in these situations. But if this is really someone who had no record of misconduct, there's no way the school could have known, and this was the first known act by that person, then the school generally would not be liable for any fault on their own. But a lot of schools that I've worked with, they want to do an independent investigation to find out why wasn't this known earlier, who was in the area of other interactions, and did they report anything, and what happened then? That's a big part of a school's response in being responsible for an allegation like this. Why did this happen? Why wasn't it prevented earlier?
I also think of the response from police where, you have this one case you're going to prosecute against her, that she sent this message to the student, then she allegedly goes to try and pick up the student, and then she gets arrested. And then I'm sure they'll look into her interactions with this student. But how do you make sure that this isn't the first, that this is the only student that was involved in something like this, and that there wasn't, in the past, any sort of thing that was missed? Who does that investigation? How do you make sure that it's a good investigation to make sure there aren't any other victims out there?
Right. Well, that's the type of investigation that I do very often now. And a big part of it is, first of all, looking through electronic records of other communication. So finding out what messaging app this was on. If it was a school messaging app, looking at other communications, maybe talking to other students. You might not ask them explicit questions about whether they engage in this type of interactions with the teacher, but were there any problems that you're aware of? Talking to parents, so canvassing different people in the community to find out. Also, now that it's public, often if there are other misconduct allegations out there, they usually surface once it's public that one person is making that allegation. So if there are other students who had communication with this teacher and parents knew about it but didn't report it, often this is the time they start to do that.
Yeah, I mean, just a shock. It does, we'll see what else comes out, but just even that one message, is enough as someone. You're like, oh my gosh, how did this happen? We'll see how the legal process plays out. Dan Shore, it's always great to have you. I know you wrote a book, Open Bar, that, for people who, are interested, concerned about these stories that we cover, that can, be a great book for them. Where can people find it?
Sure. So Open Bar is a novel. It's a fiction story based on my experience investigating these types of cases. And people could go on Amazon or anywhere else books are sold, or they can find me on Substack, where I write a lot about fiction writing and the issues we talked about today.
Yeah, and important issues to talk about for sure. Dan Shore, retired sex crimes prosecutor. Thank you as always for taking time to be with us. We appreciate it.
Great talking with you. Thank you.
That will do it for On the Case, presented by Law&Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.